Hello, I'm Gary Finklea, an attorney in Florence, South Carolina. Today I wish to speak with you regarding one simple fact, and that is what to do if you are served with a summons and complaint. I'm specifically going to gear my talk with you toward a complaint in a mortgage foreclosure process. First, in any case, if you are served with a summons and complaint, you must answer that lawsuit within 30 days. If you fail to answer the lawsuit within 30 days, you will be held in default. And the way I generally describe default to my clients is you automatically lose. The other side gets what they ask for. Now, when we use the term answer in the legal profession, that's a term of art. An answer is a specific document. I had the opportunity to argue a case before the Court of Appeals many years ago, and the Court of Appeals held and agreed with me that the defendant's apologetic letter to me was not an answer. An answer is a written document that you file with the clerk of court and you send to the opposing party admitting and denying and taking issue with the lawsuit. That is an answer. Far too many times these days, particularly in connection with mortgage foreclosure cases, defendants, homeowners, consumers, borrowers are misled. On the one hand, you've got a lawyer foreclosing on your house. On the other hand, the borrower gets letters from the lender directly stating, hey, we can help you save your home. Correspond and communicate with us. Well, far too many times defendants ignore the lawsuit, thinking that their communication directly with the lender is going to stall, delay, and save them from the lawsuit. That is not the case. I cannot name any occasion, in fact, where that is the case. However, I can name dozens, more than dozens, 30, 40 cases where just the opposite happened. If you fail to answer the lawsuit, you're going to automatically lose. I don't care what communication the lender is sending you. You are walking into their trap. You lose any legal defenses that you have to the case. The sum of it all is the best solution is if you get served with the summons and complaint for any type of case, particularly mortgage foreclosure, is that you come see a lawyer. And we'll be more than glad to help you. A lot of attorneys in the PD, just like our firm, will be glad to see you for the first occasion for free without any cost to brief you and describe what your rights are. More times than not, we can provide you a legal defense. Sometimes we can completely defeat the foreclosure. Now, I can't give you unrealistic promises, but the very best case that I ever had was a poor lady who lived in front of McLeod, was taken advantage of by just a very bad lender. And not only did we save her from being evicted from her house, which was scheduled to happen in about 10 days, we completely reversed the mortgage foreclosure process, and then we got the note canceled in that case. Now that is a rare thing to happen, but we did it. But for the most part, if you are served with a summons and complaint for mortgage foreclosure, come see a lawyer. We can help you. You've got to answer in 30 days or else you automatically lose. Don't fall victim to the mortgage companies falsely luring you not to do anything and just communicate with them to modify your loan. I've got one modification process that's been going on for 5 years. Of course, in the meantime, the client hadn't paid a dime to the mortgage company. She's been making escrow payments to an escrow account established for that purpose. But these mortgage companies just don't operate, many of them, like reasonable business people and reasonable people would. So come see a lawyer for help. Thank you.